In a landmark 6-3 Supreme Court decision written by Neil Gorsuch, the Supreme Court has officially ruled that the Civil Rights Act of 1964 extends to protect gay and transgender individuals from discrimination in the workplace. This is a huge and very exciting victory for LGBTQ rights, not just in America, I should say, but around the world too, because we constantly see that America's position on particularly social issues can influence what other countries do around the world. So this is incredibly exciting. This is really good news. And first, I want to take a look at some public polling just to, sort of talk about that. And then we're also going to talk a little bit about what, the big debate which is going on, which is I mentioned at the beginning that Neil Gorsuch wrote it, but we also saw Justice Roberts, another conservative, going over to the quote unquote liberal side. And I want to talk a little bit about why that is and, not just their arguments, but why there might be a break between what we might call originalist and textualist. All right, but here's the public polling here. So you can see here, overall, the American public is in agreement with this Supreme Court decision. 83%. I mean, when was the last time you saw an 83% agreement on a quote unquote controversial issue? You can see here, 83% of people agree that it should be illegal for employers to be allowed to discriminate or fire someone on the basis of sexual orientation. Only 17% saying, yeah, well, if they're gay, it's okay if you get fired. Among Democrats, unsurprisingly here in terms of political breakdown, unsurprising, Democrats, 90% are in agreement that it is not okay to fire someone on the basis of being gay. 11%, obviously they're rounding a bit here. 11% here saying that it is okay of Democrats, 84% of independents to 17%, and then among Republicans, still 74% saying that it is not okay to fire someone for being gay, which really just goes to show you the massive swing in public opinion when it comes to LGBTQ rights in this country. The just massive and very, in many respects, rapid swing in public opinion just goes to show you the success of this movement. I do think that studying the way in which LGBTQ has sort of how the various activists communicated and sent around their messages across the country is something that we should all study if we want to understand how to be successful politically, because I've never seen, I suppose that, I suppose maybe I'm a little bit young here, but I cannot really think of any other political issue which just saw that massive swing where everybody, just sort of changes their mind. Once the activists started talking about the issue, just people very quickly became persuaded, not just of gay marriage, but then also about protections for discrimination. And you can see here, when it comes to transgender individuals, 79% of individuals believe that discrimination on the basis of being transgender should also be illegal, which is in many respects hardly any different at all from Americans who think that it should be illegal to discriminate on the basis of sexual orientation, which goes to show you, by the way, because there was a lot of controversy initially when it came to adding the T to the LGB movement, right? Because for a while there, back in especially like the 80s, it was the LGB movement, and they didn't really include transgender individuals, but adding the transgender into the movement, right, while it was controversial at the time, was incredibly successful at pushing forward the transgender issue, because people, sort of came in agreement on the issue of gay marriage, and then were, sort of opened their mind and listened on the issue of transgender, on the issue of transgender, the very, very important and critical issue of transgender rights as well. And it really goes to show you that it's really possible, again, to change people's minds, because initially the whole thing, transgender rights was much, much, much more controversial than gay rights, but, connecting those two issues together really made it so that it wasn't like sort of two different fights in terms of civil rights, in terms of various kinds of discrimination protections. It became one single fight. And that's why, even the transgender issue was able to accelerate so fast. In fact, in many respects, accelerate even quicker than the issue of gay marriage. So it's really exciting to see this swing in public opinion. Even Republicans, 69% of Republicans say, no, you shouldn't be allowed to fire someone just because they're transgender. That's wrong. I think that you should not be allowed to do that. So this is definitely something, this Supreme Court decision is definitely something that most people are in support of. Even Donald Trump came out and said, well, he claimed to have read the Supreme Court decision. I'm not sure that I buy that. I'm not sure that he actually read the couple hundred-page Supreme Court decision. I skimmed it, but I'm not convinced that Donald Trump read it. But, even if he did, regardless, he said that he, that's the ruling now and we're going to stick with it. So he's not fighting it. He's not going against it. That's the messaging out from the White House that, okay, that's the decision of the Supreme Court. All right, then. So that's also good to know, that we're not going to hear, they hopefully, right, won't be trying to scratch away at the various kinds of protections how they can. So that's exciting to see. Now, I want to take a little look here at why the sort of split occurred. So this is sort of the opinion written by Neil Gorsuch here. So actually, before we go into this, let me quickly explain here. So there's a general split among conservative judicial philosophy between what you might call textualist and originalist. Textualists argue that you can have a kind of self-consistent set of laws, right? So the law is the law, basically, and you're only supposed to be interpreting the law. You're not supposed to be a kind of judicial activist, whereas originalists say that the only way in which you can interpret the law is by looking at the intentions of those who wrote the law in the first instance, right? So there's a bit of a split there, and it does show why some of the conservative justices went over to the quote-unquote liberal side of the bench. So let's read the decision and see if we can kind of, think through and see the distinction between originalism and textualism as we read the text of this decision here. So here's a page from the decision here. It is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual on the basis of sex. So that's the claim. So let's look at the argument to back up that claim. Consider, for example, an employer with two employees, both of whom are attracted to men. Okay, they're both attracted to men. The two employees are, to the employer's mind, materially identical in all respects, except that one is a man and the other is a woman. So you have two employers, there are two employees, they're both the same, one's a man, one's a woman, and both of them are attracted to men. If the employer fires the male employee for no reason other than the fact that he is attracted to men, the employer discriminates against him for traits or actions it tolerates in his female colleague, right? So if the claim is they are both the same because they both discriminate, because they're both attracted to men, but one's a man, one's a woman, well then one's gay, and then the other's straight, being the woman, well then you've discriminated against the man for being gay because you've discriminated against the man for being a man, you've discriminated in him on the basis of sex. And so it's basically not okay here. So it's absolutely fascinating, a really interesting argument here. Put differently, the employer intentionally singles out an employee to fire based in part on the employee's sex, and the affected employee's sex is a but-for cause for his discharge. So interesting argument here. Now, the other thing I want to take a look at here when we look at this argument to try to understand the difference between originalism and textualism is this quote here, and then we're going to sort of break it down a bit here. So you can see here, those who adopted the Civil Rights Act might not have anticipated, and again, remember, this is written by Neil Gorsuch, the textualist, might not have anticipated that their work would lead to this particular result. Likely they weren't thinking about many of the act's consequences that have become apparent over the years, including its prohibition against discrimination on the basis of motherhood, or its ban on the sexual harassment of male employees. But the limits of the drafter's imagination supply no reason to ignore the law's demands. When the express terms of a statute give us one answer and the extra textual considerations suggest another, it's no contest, right? So I said at the beginning here that one of the major differences between textualism and originalism is that originalism thinks that the only way to interpret a particular text or statute in a law is by looking at the initial intention of the authors who wrote it. You saw there in that text, Neil Gorsuch at the get-go is saying, actually, no, the limitations of the writer's imagination for how they wrote the law supplies no reason to limit the actual meaning of the law itself. So the law is in some sense independent of the person who wrote the law, right? Whereas originalists argue that actually no, by trying to go back and try to, sort of figure out what the law really means, what you've done is become a judicial activist. So you'll see right now, if you go on social media or you go online, a number of conservatives are blasting Neil Gorsuch, saying that he's changing the meaning. He's changing the meaning of the 1964 Act, right? He's adding new sort of terminology, adding new content into the legal meaning of what sex actually means, because the concept of sex does not mean gay. The concept of sex does not mean transgender. But the textualists look at that and argue, well, actually, the sort of implications, if you sort of reason through the premises, reason through the meaning, actually does have that implication. So it's a philosophical difference which led to this distinction. Both views, the textualists and originalists, are different kinds of conservative judicial philosophies, because the textualists, of course, would look at the originalists and say, well, hold on, you're looking at something other than the law. Right? By looking at, okay, reading other letters, reading other text that, say, James Madison or, Thomas Jefferson may have been thinking about when they, wrote another text. Well, you're looking at another text out there and then inferring into the law additional meanings that is not in the law. Whereas originalists say, no, well, you are inferring additional meaning into the law by adding in terms to a particular, relationship between subject and predicate, by, deductively deducing the implications of a particular, I said that a little bit backwards, by deducing the sort of deductive outcomes of, a particular subject-predicate relationship, you've actually added in meaning to the law. So it's an interesting dispute. It's an interesting debate among conservative judicial philosophers. Now, I will say, just super briefly, without going on too much of a tangent, part of the reason why this sort of split even arose between originalists and textualists actually had to do with the failures of logical positivism in the sort of 1950s and 60s. Now, logical positivism is a school of philosophy which said that you can actually use sort of empirically verified premises and use logical deduction to create an entire set of possibly explainable philosophical terms. That any meaningful philosophical problem is one that has empirically verifiable premises or which can be included deductively. But it became clear that you cannot actually have a self-contained set of self-consistent, self-referential axioms in any particular philosophical system. Right? And so as a result, people became originalists and said what you actually have to do is add meaning into a particular text, add information from, dictionaries at the time, from letters written at the time, that was the originalist, in order to make sense of a set, because the law cannot exist independent of some kind of hermeneutical system to interpret it. So it's a really interesting philosophical dispute, a really interesting philosophical divide that's super important to understand, and is, goes to show you how philosophy can influence law. And in fact, even aspects of like, Gödel's incompleteness theorem was related to the downfall of logical positivism. So you might even be able to make, a super extended argument to how this mathematician's obscure theorem ended up having a connection to the Supreme Court decision. I mean, you'd kind of be pulling things a little bit far, maybe really sort of stretching things to make that decision. But you could kind of draw that. So I just think it's super fascinating when you start thinking about the way in which, seemingly obscure, seemingly abstract academic problems actually end up having material and real impact, real influence into the world. And it's interesting to see, man. It's interesting stuff to see. So anyway, I just wanted to talk about that, give you guys a little bit of background on some of the legal theory going on, hopefully explain to you why conservatives were going over to, to these quote unquote liberal side of the fence on this issue. So anyway, if you like this video, I'd really appreciate it if you hit the like button and consider subscribing. Thanks.